I couldn't hear you, Your Honor.
We're not able to have an inmate for that prior case, so we have to reset it.
Oh, okay, that's fine, no problem. So, are you gonna call him? You're gonna call him here?
Did everyone check their cell phones to make sure I'm not?
You want a water?
Yes, ma'am. Yes, ma'am.
You swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Alright, and Ms. Lopez, what is your relationship to the respondent?
And Judge, if sorry to interrupt, but there are a number of potential witnesses in here. I think we might want to invoke the rule just to be safe.
Anybody is here to testify, to be a witness, I'll ask you to step out in the courtroom. Out of the courtroom. And we'll call you back in with your.
Your Honor, my name is Stacey Lopez. I work for the South Daytona Police Department. I'm the records custodian and assistant to the chief records supervisor there.
Okay, so you've encountered the respondent in your work capacity?
Yes, ma'am.
Okay. And if you would just explain why you believe an injunction for protection is necessary.
Can I go up here or should I stand here? Stay here? Okay.
Wherever you come from.
So, Your Honor, my name is Stacey Lopez. I am requesting a permanent injunction for protection against stalking pursuant to Florida Statute 784.0485. I am a records supervisor, assistant to the chief of South Daytona Police Department, and a public service employee. The respondent, Mark Dickinson, is a self-identified First Amendment auditor who is repeatedly targeted in a manner that has caused me substantial emotional distress and has put me in fear of my own safety and disrupting my ability to perform my essential job functions. While I fully respect and understand the rights granted under the First Amendment, the respondent's conduct goes far beyond lawful activity. This is not about simple reporting or holding the government accountable. This is about a pattern of willful, malicious, and repeated harassment. It is attempting to protect behaviors under the guise of First Amendment auditor rights, all the while just harassing me as a public service employee. Especially when I don't do things the way Mark Dickinson wants them done. If I don't fulfill the request the way he thinks they should be completed, this behavior escalates to frustration and throwing fits or tantrums in an effort to force or intimidate me into fulfilling those requests. There have been several separate incidents where the respondent has come to my place of work, recording me without consent, following me around the facility, making inflammatory or degrading statements, and in some cases, posting these interactions online with captions or commentary intended to provoke public harassment. I have evidence that the respondent returned multiple times, even after I've requested to stop the video or not be recorded, and after law enforcement has been contacted. This behavior is not productive behavior for the valid purpose of First Amendment auditing. This has become personal attacks on me and other employees. Behaviors such as making statements that I know where you live and I know where your husband works, and standing outside the PD holding up signs that say, "Fuck Pignataro, the cover-up king," are not First Amendment auditor rights. They are personal attacks on public service employees. The conduct has served no legitimate purpose as defined in Florida Statute 784.048. The respondent is not engaged in journalism or civil discourse. He is using the label of First Amendment auditor as a shield for behavior that is clearly intended to intimidate and provoke. I have experienced anxiety, fear, and disruption to my work and personal life as a direct result of these interactions. In my view, this conduct fits the legal definition of stalking and harassment under Florida law. The repeated, targeted nature of the respondent's behavior toward me is not protected speech. It is a personal campaign of intimidation, not a public accountability effort. Your Honor, I am most fearful that if this injunction does not stay in place, the continued abuse and harassment will further escalate. We can clearly see how he behaves without the potential for an injunction being imposed. Could you imagine how he will behave if the injunction does not get put into place? Especially because he has been served, there will be the immediate escalation of threats, intimidation, and defamation in an attempt to make him feel and look better as a result of the embarrassment he may be experiencing due to his own actions. For these reasons, I respectfully ask the court to grant the injunction and help restore a sense of safety and normalcy in my life, my family, and my workplace. I am seeking protection from my current and any future place of employment, protection from my husband's place of employment, and protection from my home and my children's school and extracurricular activities. Thank you.
When
was that an opening statement or?
It was.
Okay, I just want to make sure because you referenced your husband and you referenced this. I just want to make sure you understand. I don't know any of the factual background and you have to, you know, like you referenced repeated targeted attacks.
Sure.
You have to go through them.
Yeah, I can go through them.
Well, it's your case.
Yeah.
You're seeking an injunction, so.
Right.
If that's an opening, I can go to, is it leasing or leasing?
It is licensed, Judge.
Leasing, all right. If he wants to make an opening, and then I'll come back to you.
Sure, Judge, I'll be brief. As Ms. Lopez has indicated, my client is essentially an investigative journalist. He has a YouTube channel with approximately 400,000 subscribers. What he does and his goal and purpose is basically through usually obtaining of public records and other sources. He will investigate matters of malfeasance related mainly to law enforcement or other governmental agencies. The context of this injunction is simply this. When Mr. Dickinson goes to South Daytona Police Department to engage in public record requests, Ms. Lopez has been the one who is responsible for basically gathering those requests. As this has progressed over the years, what has happened is clearly there have been a number of personality conflicts between the two. Now, there are a lot of allegations that Ms. Lopez referenced regarding threatening behavior. We don't agree to any of that, obviously. We have witnesses, I think, that would contradict some of that testimony. However, the crux of this, again, is Mark Dickinson is going to the South Daytona Police Department to engage in a protected and legal duty, which is to obtain public records. He doesn't care if Ms. Lopez is there or not. He is simply going there to engage, again, in the role that he has permission to engage in. However, Ms. Lopez, I think you'll see through testimony, has often inserted herself into the process. As somebody who says they're unfair and needs an injunction and all these other things, we have videos because essentially everything Mr. Dickinson does is on video because it ultimately ends up as part of perhaps the YouTube channel and that audience. We have videos of her coming out, engaging with Mr. Dickinson, antagonizing him, her superiors saying, hey, you know, Stacy, go ahead, go back. She persists. So what we really have here, Judge, is a person who is engaging in legitimate purposes, legitimate business. However, a personality conflict has been created between these two. Prior to this hearing this morning, there have already been remedial steps taken. In fact, there is evidence. We have an email from 2003 in which Mr. Dickinson emails the chief of South Daytona and says, I don't want to deal with Ms. Lopez anymore. Give me a different way. That basically falls on deaf ears, obviously, as this continues over this period of years. However, even as recent as 2 weeks ago, after this happens, Mr. Dickinson again says, is there a way to conduct the business I want to conduct without Ms. Lopez being involved? Again, this is a personality conflict. There's no stalking here because there's a legitimate purpose, him obtaining records. I've spoken to Ms. Lopez at length this morning. I was on the way to drop my daughter off at school, and I think she and I talked for approximately 30 minutes to see if we could perhaps find a path, resolve this without this mess taking place. I mean, candidly, Judge, I think we were pretty close, in terms of, I've told my client, look, everybody can tone the rhetoric down. Perhaps we don't need the cursing or the cuss words or anything. Again, I don't think that's stalking, but we can treat people with more respect perhaps than has been indicated in the past by both sides. There were concerns about her family. I don't even think Mr. Dickinson knew where her husband worked until we looked over Ms. Lopez's agreement that she handed me in the morning. There's really been nothing about her family. Again, this is when he goes to South Daytona to conduct his business. If he was able to conduct that business with anybody but Ms. Lopez, we wouldn't be standing here. However, it seems nobody has wanted to put a plan in place that would facilitate that so that both sides can move on without the need of obviously being in court litigating like this. So it's our position, Judge, again, that there is a legitimate purpose. This isn't some campaign against Ms. Lopez where he's trying to argue with her, cause her grief, all these other things. She is in the role that is necessary for him when he conducts his business to get these records. And that's really what this is about. This is about, more hurt feelings, nastiness, things of that nature, but it's not some direct targeted attack. A lot of the emails in the petition, Judge, as I'm sure the court has reviewed, they're not even directed at Ms. Lopez. She's not even the recipient, which would be required obviously for stalking, and we get into the legality of it later. But that's really what this is. Mr. Dickinson's trying to obtain public records. Her role is to provide them. There's been a breakdown in communication. As such, some unpleasantries have been born out of that. But as far as stalking, Mr. Dickinson can go to the police department later today, and if she's not there, great. It doesn't change anything regarding what his intentions are and what the nature of his work is. These two don't get along, but not getting along or being uncivil to one another is not what stalking requires. So that's our position.
Respectfully, Your Honor, it goes far beyond not getting along because
Well, and what I would ask for you to do is present your testimony, the specific facts that you have about behavior
Sure.
that's targeted to you specifically.
Yes, ma'am.
Then I'll let Mr. Leising
Yes, you got it.
question you, and then you can make a closing statement.
Okay. So the specific behaviors that we're referencing are emails that are directly sent to me. The emails, they are not only sent to me, they're sent to other people as well. And I did include those in, and you may have seen some of those emails. I'm not sure if you have. But some of the emails that were directed directly to me are the ones that tell me, I will get to those. I would like to say one other thing also. Yes, he did send an email in 2023 stating that he did no longer wish to deal with me. That is a fact. But he continued his behavior, even violating his own request to not have behavior, continued conversation and communication with me. I'm the records custodian. I'm the one that releases the records with the city or with the South Daytona Police Department. And so for him to request to not have any communication, but yet to continue to do so in the way that he did, violates his own request for.
Let me ask you this, is there anyone else at the police department that can respond specifically?
Yes, and we put that in place. So since I filed the injunction, that is correct. He sent an email saying that he needs to be able to communicate with somebody. No problem. It's exactly the same email that I've told him to send the email to in the past, and he absolutely refused to. In fact, he told me, you don't get to tell me, you don't tell me where the fuck to send it, I send it. Pardon my language, and I'm sorry. But the emails that I get from him are ones that, tell me to go fuck myself. They tell me,
You
and
can say,
I'm sorry. I know. I just want to be as truthful as possible because I'm not here to make or exaggerate anything that's not the truth. The truth is that this is the behavior that he's exhibited even in the last 2 years beyond the 2023 email that he sent. And he says, the bitch up front is there to do her job. And that's what he sends to a former deputy chief. And then it's, he makes things like the statement where it says you can, I don't know, you have the emails, you see them, and where it says
well, let me
you
ask
can.
for today's purposes, I have the petition, so are
Yeah.
you moving the attachments into evidence, or?
I am.
All right, do you object to that?
Judge, I would only object to the ones that are not directed at her. Again, there are emails included in this packet that appear to be sent to recipients that do not include Ms. Lopez. So I don't know how those would necessarily get the court to a stalking injunction. However, as I'm aware, the court has reviewed the petition, so it's not a strenuous jump up and down objection. Of course, I would just like the court to note, I believe there are things that are in this petition, again, that are not directed in any way, shape, or form to Ms. Lopez and should not be considered. So I think it'd move more to the weight on that argument. But.
So we'll say that the attachments to the petition are admitted, but certainly you can make arguments
Yes.
about their relevance and will they establish the requirements for injunction for stalking.
So I have a timeline. Again, that timeline is attached as well. I'm sure you've probably seen the timeline. There's
All right,
nothing.
then let me make sure I'm clear on whether it's just the emails or it's everything. Let's see. What page is your timeline on?
They were attachments to them to the injunction.
Okay, I just want that. Right, the one that was right behind it that had dates?
Yes.
Okay. So I wasn't in, are you wanting that to be in evidence as well because it's?
I do. It was submitted with the injunction, and so it is.
I mean, it's the petition, so.
Yeah.
Go ahead.
Oh, with the petition, yeah. So it is, I do want to submit that as well, because this is exactly what has happened. And so I don't have anything outside of this timeline here. what's on the timeline, these chain of events, this is exactly what has happened and why we're here today. He continued that behavior to the very last incident, which is where he sent an email to the city clerk, the city mayor, the city manager of Volusia Exposed regarding my personal credit issues. And here's the thing, he sent a screenshot of the court cases, but doesn't send that they've been obviously dismissed. So it's clear that the intent here is to damage my character, harass me, cause great harm to me, because I could potentially get in trouble, lose my job. Even though I told my HR director what was happening, there's nothing in policy and procedure that says you can't have a bad credit card. It was a bad time in our life. They've been taken care of. They've been paid. He also asked for my previous employment, or asked for my memos where I've requested, or where I request for approval to seek outside employment. I have outside employment. How do you know that? How do you know I have outside employment? Because you've obviously done your research. And you know, you're stalking and seeing what else can I try to get this person on? How else can I go after her real estate business? How else can I go after her consulting business? Whatever it may be, why are you asking for, when I used to teach at Embry-Riddle, why are you asking for my proofs of employment for 23, 24, 25? Clearly, those have been able to put me into a better financial situation and take care of those few little things. And I clearly explained to him, I even explained to him why those things took place, why those credit cards were the way that they were, and explained to him that my husband was injured in the use of force at his place of employment, couldn't get cleared to go return back. So guess what? I had to do what I had to do. It was my mortgage or my credit cards. What are we paying here? And you know what he writes back to me? He goes, I think he says, I can't remember now because now I'm remember. But anyways, it just makes a smart comment back about how I worded the email. There's no trickery. That's the facts. So at what point does it stop? And at what point does it escalate? Where does this behavior end as a personal campaign and attack against me as a public service employee? I have never once denied Mark Dickinson a single record. He just doesn't like that I make him pay for it. Per Florida statute, by the way. So it's not that I'm and I've given him free stuff too. So it's not about that. It's about your personal attack to me, because otherwise, why are you sending my whole credit? It's 4 or 5 little credit cards. You're sending them to everybody, the city mayor, the city manager, the city clerk. For what? Tell me, what good purpose does that serve? Because I have a pathetic $3,000 or $5,000 city credit card? That's worth my entire career. I'm 50 years old. I've been in law enforcement my entire career. I was a misdemeanor probation officer at 18 years old. You think I'm gonna throw my whole career over a $3,000 credit card? So tell me, what was that point? What good purpose does that serve other than harassing? And I give him the costs that are associated with it. He then complains of a paper cut, asks me to give him a Band-Aid, which was provided. These are just so frivolous. He files a complaint against me with the city, a frivolous complaint, just so that it goes on record that he's filed a complaint against me. And it only stays for a year per Florida state statute because it was unfounded. And why was it unfounded, Your Honor? Because it's frivolous. We have video. I gave him everything in the police department that he asked for, showing he came in for the request. I gave it to him, and that's the reason it was unfounded. But this is the kind of stuff that he does. I don't know of a single other administrative assistant in the county that has put up with the behavior from him that I have. I don't know of a single other assistant that's had, you can wipe your ass with this email. I don't know of a single other administrative assistant.
Judge, probably gonna have to object to relevance as it relates to other people, just for the record purposes.
This is me
I'll
personally.
sustain the objection. You're just saying for me to consider what other people have had to deal with.
No, I'm saying me personally.
Okay, well, I'll sustain the objection.
So, anyways, that's where we
Any
are.
other items?
No.
Okay.
A couple of questions, Judge, I'll be brief. Ms. Lopez, you referenced this, the credit history stuff. Now, you would agree with me that those cases, those instances are all public record available on the clerk's site to basically anybody who wants to look
Yes.
you up and find that information,
I
correct?
agree, yes.
And you said that that was sent to your superiors, correct?
That was to city, to the mayor.
Right, to other public servants and other offices that are related to public service.
Other city officials.
And the tenor of that was, basically, Mr. Dickinson was saying, you're in a role that deals with finance and such, and he was concerned about problems with your personal finance. That was kind of the gist of why he did it, correct?
I don't know.
So you don't know his purpose?
Correct. I
Okay.
want to know what valid purpose, because you can say that that's what you're doing, but if that's the case, why do you not show
Well,
the
let me
disposition of those cases?
Well, let me ask you this. That is obviously a very important part of the context here to you, and I understand that obviously, we all have our, dirty laundry or skeletons in the closet that we don't want out there, but it sounds like you went ahead and explained to Mr. Dickinson what caused these complications in the past and had a productive conversation with him regarding
Oh, no, it
those
wasn't
specific, well, to at least get out there, hey, this is why this stuff happened,
And he
right?
didn't care. So here we are again, because he continued, he sent it, then after that, he sent it again to city officials.
Right, but-
So even after I explained myself, he again sent it back to the city officials, continuing to harass me about that
Right,
situation.
I understand that though,
Okay.
but what I'm suggesting is here, you're asking the court for an injunction against stalking, yet you are having a conversation with him, telling him the details of this information that has you upset.
Harassment is under the insulting
Well,
injunction.
I understand that, Ms. Lopez, and I get that
So-
part, but what I'm saying is,
Why are you only stalking me?
well, but you engaged with him and offered him examples of why those things exist in your history,
Yeah.
correct?
And he
Okay.
continues to stalk and harass.
I understand.
Okay.
All right, so I want to talk to you about a couple other things. You mentioned reference to, prior employment, current issues with employment, so on and so forth. I mean, Mr. Dickinson has made a request for your personnel file,
The
correct?
entire personnel file.
Right,
yeah, twice.
and that is, and you would agree with me, Ms. Lopez, that is protected behavior. That is legal. Anybody can walk in off the street and say, I want this person's personnel file.
Correct. If you're wanting to harass them, yes.
Well, but that could have,
Legal or not?
well, but that could have a multitude of reasons, right? If Mr. Dickinson is looking to uncover some sort of scandal or malfeasance or such, obviously looking into people's backgrounds, especially a personnel file, would contain information perhaps related to misconduct and such, at least alleged to have been done by that party,
And
correct?
when it didn't,
No, I understand, I understand.
okay. So
And,
when it didn't, in the personnel file that he's requested twice, when it hasn't exposed any kind of wrongdoing, because I have had a stellar record, oh, by the way, for nearly 10 years with the agency.
I get it, and again, I'm just asking you to talk to me about, these specific requests and those purposes. I understand, again, your record and such and how it's valuable to you. I'm not getting into any of that with you. That's not up for debate. When Mr. Dickinson, I'm sorry, didn't mean to cut you off. When Mr. Dickinson comes to South Daytona Police Department, you would agree with me that his purpose and his goal is to obtain public records, correct?
Yes, that is what he is requesting, are
So-
public records, and I've never denied a records request.
And you would agree with me, Ms. Lopez, that Mr. Dickinson has never shown up to the South Daytona Police Department, walked in and I'm just here, where's Stacy Lopez, and has you come out and just is there for no other purpose than just, I want to see Stacy Lopez and I want to, engage in A, B, C, and D. It's always him showing up to get public records. That is your role, so when you come out to provide that duty, there is obviously headbutting between the two of you, which is clearly borne out of your testimony
This
this
is
morning.
far beyond headbutting.
Well, I get that, but
Okay, as long as you
Mr.
get that, then you understand why we're
Ms.
here.
Lopez, just let
But-
him ask the questions, you
but-
answer, and then I'll ask if you have anything you want to add.
Okay.
But again, Mr. Dickinson's purpose and role when he goes there, though, is to obtain records, correct? Bottom line. You would not
Allegedly.
disagree with that? Well, you say allegedly, but if he's there and getting public records, Ms. Lopez, help me understand how it would be allegedly his purpose. If he shows up and says, I'm conducting this request, and hands you that request and whatever exchange there is, that is his purpose, correct? You'd agree with me that that is his purpose?
Because he doesn't just show up. He emails these requests. And
Right, well,
that's when
right.
the communication becomes far more than just a records request. Because that's when the behavior becomes, and beyond those records requests, again, like when he emails other people and says what he says, that be up front. Why are we talking about me? Why is it after I filed the injunction, after I filed the petition for the injunction, he calls the former deputy chief talking about that F.N. Lopez filed an injunction against me? The former deputy chief, the day you get served.
Right, I mean, well,
It's not his friend.
Well, he's allowed to be upset about it, correct? I mean, he's being accused of stalking. I mean, anybody put in that position, just like you're upset about what you're accusing him of, he's upset about what you would agree with that being, plausible under that set of circumstances, correct?
Disagree.
Okay. As far as you being in this office, so when Mr. Dickinson walks into the South Daytona Police Department to obtain records, you're not even sitting there right at the front counter waiting to
Correct.
greet him, correct?
Correct.
In fact, your office is a couple of sort of
No.
quadrants or however we want to.
One over.
Right. So, but he walks in, he doesn't even see Stacy Lopez when he walks in, right?
Correct.
Okay. And in fact, there are a number of instances where you have come out to deal with him, and
Because I'm the records custodian.
but when he is engaging in this behavior that you're alleging is stalking, you've had many instances where you've kind of given it right back to him. Oh, I'm going to record you too, or I'm going
I
to.
never said I was going to record you too. I said one day the auditor will get audited.
So there's never been a circumstance, Ms. Lopez, where Mr. Dickinson shows up to get records, you come out of your section of the office, and there's a back and forth between the two of you, even to the extent where you're told by a superior, Stacy, go back, we got this, let me deal with it.
You're talking about
And-
the same incident
Right.
from 2023.
And you even in that instance.
Because he
were-
had threatened me that day, and I called out to the sheriff's department, or I called the sergeant to file charges against him for harassing me because he threatened me, told me that, and I said, are you threatening me? And he said, yeah, I'm threatening you.
That's all on video though, right?
That's right.
Okay.
So again, I was gonna file charges that day. We ended up making just a CAD comment as a result. That's when Deputy Chief came in. I was telling the Deputy Chief what was happening. That Deputy Chief then told me to step away. That's what happened.
Right, and in fact.
Again, it's just behavior.
Right, but you didn't, the point of this is, Ms. Lopez, is you didn't step away. You continued to engage.
No, I
with
walked
Mr.
away.
Dickinson.
That was it. When the Deputy Chief, they walked outside.
Okay. No. And that is on video though, right?
Yeah, they walked away. The Deputy Chief told me to walk away, he said, or to leave it alone or whatever, I don't remember exactly. And then he and the Deputy Chief, if I remember correctly, walked outside. That's the same day that he said, I don't want to have any more communication with me, whatever. And then still continue, because all the emails that I sent,
Right.
when he's like, F that B, do this, whatever, all these,
Can I just clarify,
Okay.
what was the date of this interaction that you had?
2023.
23 judges.
Or 2023. So the emails,
Okay, so Ms. Lopez, just though, I understand, the F this, the F, all the cursing and the cuss words, but, I mean, you would agree with me that while we don't like that is not illegal.
I would say that I say it is illegal under the guise of trying to be a First Amendment auditor and harassing a public service employee. I'm a public service employee. You don't get to treat me like that any way that you want just because you are a First Amendment auditor.
And I'm sure other people, you've been there for many, many years, I'm sure you've had unpleasantries exchanged with
Not like
just,
this.
but with other people, I mean, this happens, right?
No, I certainly have never.
No one else has ever
Not a single
cursed or
person.
cussed or anything like that
Not
in
me.
your entire career?
In the 9.5 years I've been with that South Daytona Police Department, never once have I had somebody speak to me, treat me, harass me, request records on me like Mark Dickinson, ever.
All right.
In my entire, actually, you're right.
And you're still employed, obviously, with this agency, correct?
Yes, I am.
Your employment did not suffer in terms of, you were not fired or placed on any sort
Not
of
yet.
probation or anything like that, correct?
As of today, if that is correct.
Gotcha, okay. So again,
But
none
this
of his
continued
actions have caused you disciplinary protocols at work.
I had a complaint filed against me.
Right, but I'm saying like actual discipline problems, pay cuts, demotions, things of that nature.
Not as of today.
Okay. Judge, I don't have any further questions at this time.
Okay. Is there anything you want to say based on questions? Yes.
I want to know, when does it stop? I want to know, when does it not become criminal? I want to know why it is that this behavior is acceptable as a First Amendment auditor against a public service employee under this threat of intimidation and fear, and that you can behave however you want to because you're a First Amendment auditor. I don't deserve that. I'm a public service employee. I've had a master's degree in criminal justice and been doing this a long time. Not in my 32 years as a criminal justice employee have I dealt with this behavior, ever. He can say what he wants, he can interject, he can have some sort of defense, but no matter when the rubber meets the road, it's in writing, it's in emails, whether to me or to somebody else, that it's clear harassment under Florida state statute. And for those reasons, I need protection, because this kind of stuff infuriates Mark Dickinson, and it will escalate. And so I did offer an agreement prior to coming into the courtroom and had said, just don't bother me at work. You can come do your things at South Daytona Police Department, no problem. You can do your public service work, no problem with doing with what First Amendment auditors have or have the ability to do, none whatsoever. Just don't mess with me, don't mess with my family, and don't say you don't know where my husband worked, because you clearly said to me one day Tomoka, which was a previous employment. So, again, I put in the agreement that he is not to mess with my children's school and their extracurricular activities and those kind of things, because I wanted a totality of protection. And if that's the only
I just asked a
reason,
clarifying question here. Have all of your interactions with Mr. Dickinson been at the police department or by email to official email?
most of them, yes, but he follows us around the police department. So even as we're pulling in, he'll pull in behind us and things like that. And so that's where I get a little bit nervous. And then the day after I filed, the day he was served, interestingly enough, and I can't prove this, but I'm gonna say it, I had a Tesla follow me at Dick's when I went to Dick's Sporting Goods. Followed me in, went inside, when I left, followed me out. And I thought, well, that's interesting. Unfortunately, I didn't get the tag number. That's the only other incident that I can reference. But other than that, all interactions either take place, he videotapes our vehicles, inside the vehicles. Those are my personal vehicle space. Why are you by my vehicle? Tells me I know where you live. Okay, I live out in DeLand. Not even near here. So anyways, yeah, but most of the behavior, most of the interaction is at the police department. We have a thing in place where yes, he can come in, get his records. What I'm saying is I want protection from him being able to continue to post YouTube videos, because that was the other thing that was in the agreement. So there's a few things in the agreement that they don't like.
Well, and I understand you all were trying to come to an agreement, so that's not what the court considers.
I understand.
And I just want to make sure we all understand too, I'm not deciding what behavior is appropriate. I'm just determining whether an injunction is necessary to protect you from being a victim.
Right.
Yeah.
And I am clearly being harassed. It's clear as day. Of course, in my view.
Counsel?
Judge, I would, at this time, I'd move to dismiss this petition. The court's previous ruling obviously was to not grant it to have this hearing. I don't believe there's been any real change in circumstance here. In fact, I think what's been brought to light more than even being pled in the petition is the very nature of this interaction between these two people. Mark Dickinson goes to South Daytona Police Department with legitimate specific purpose to obtain records, and then butts heads with this individual, and I just don't know who, if I could ask who the petitioner's talking to in terms of, we're kind of in the middle of testimony, but. So in any event, Judge, there's a bunch of case law that I know the court's aware of and I've brought for all the parties that talks about, first, the legitimacy of the purpose. And again, he is conducting a legitimate legal purpose of obtaining public records. All of this conduct is at the police department, which is open to the public. That's one thing that a lot of these stalking cases look into as far as the locations and the locale, again, a place open to the public. You've heard testimony, she's not even out front. She has oftentimes inserted herself into this situation, which again exacerbates this headbutting between the two. But Judge, at the end of the day, what this is really about is language she doesn't like, emails being sent to people about her. All of this is completely protected and legal. She just doesn't like it, and it's created bad feelings and hostility between the two parties. As far as the agreement is concerned that's been referenced, obviously, Judge, the whole tenor of it is, well, she doesn't want to deal with these hostilities with Mr. Dickinson. I get it. I mean, we're looking for an alternative avenue that's already actually been put in place by the police department. There's just no need for an injunction for that reason alone, but because there's no stalking here. This isn't a thing directed at Ms. Lopez. If she left the department tomorrow, he would go in, get his public records, not deal with her. None of this wouldn't exist. This is a personality conflict. You know, Judge, the case that always brings to mind, you know, I like to quote, obviously I'm sure the court's heard it a bunch, but let me go through my cases here real quick. When you look at this conduct specifically, let me find it here. It's in the case, and again, I'm sure the court's familiar. I'll bring a copy up here in a moment. Jones versus Jackson. This was an injunction dealing with stalking, emotional distress. I always like the language in Judge Alterbrun's concurring opinion. It might occasionally be helpful if the circuit court had powers to enter an order requiring adults to act like grown-ups. But a permanent injunction for protection against repeat violence cannot be used simply to compel civility and common decency. That's what this is about. Could Mr. Dickinson perhaps tone down some of the rhetoric and the language and such in the back and forth? Sure, he could. I've advised him he should, just as professionals in his role, to not have to end up in circumstances like this. However, it's not illegal. It's not stalking to send an email that says F you or say things we don't like. And that's, again, what this is really about, is civility and decency, which has deteriorated to the point, here we are, in court with witnesses, everything else that's taking place. It doesn't warrant a stalking injunction, perhaps a stern, hey guys, let's quit this, or we're gonna be back here, this could happen again. Absolutely, I get it, but the merits are just not met. The legal burden has not been met in terms of Ms. Lopez to say to the court, I need to be protected from stalking from this person, because that's simply not what this entails. It's legitimate purposes with a breakdown in communication that, again, has led to this unfortunate consequence.
And Your Honor, one other point I'd like to bring up is that he brought up my mother's foreclosure in that statement that or in that screenshot of the cases. That wasn't against me. I was the heir to that estate. And I explained also in that email, it was my mother who died of cancer, oh, by the way. And it was that, at that moment, that I realized that if you're harassing me about my deceased mother case of a foreclosure, which, oh, by the way, I won, okay? Because why? It was wrongly done in the first place. So I won that case in the courts by myself, without an attorney, and sold that property. Why are we bringing that up? So again, I just seek protection.
Counsel's argument, if you can, about essentially what the court determined is whether you have presented sufficient evidence to support an injunction.
So I believe that I have submitted sufficient evidence based on the emails that I have presented, the copies of the continued behavior even after trying to have decent communication, and he continues to send out the emails to other city employees and officials. It absolutely meets the criteria that an injunction should be put into place. There should be some sort of protection for me against this type of behavior. You should be able to be a First Amendment auditor, but you should not be able to harass me as a public service employee.
Well, I appreciate that. I appreciate your testimony. Based on the state of the law, I do not think that evidence is sufficient to support an injunction for protection against stalking, so it will be dismissed.
Right.
All right, as I said before, I'm not condoning any language or tone or behavior. It's just, does this meet the legal definition or not? And then, all right, so it is dismissed.
Thank you.
Thank you, Judge.
Thank you, Your Honor.